Good morning. My name is Mike Doucette. I'm the Commonwealth's attorney for the city of Lynchburg. Back on November the 19th of 2014, by order of the Virginia Beach Circuit Court, I was appointed as a special prosecutor to investigate whether or not Mayor Will Sessoms of Virginia Beach perhaps had violated the Virginia Conflict of Interest Act. As a result of a long investigation, as of yesterday, I directed Special Agent Rob Cully of the Virginia State Police to go before the Virginia Beach Magistrate and ask for 5 summonses alleging that Mayor Sessoms violated the Virginia Conflict of Interest Act between the years of 2012 and 2014. Specifically, the summonses deal with 3 different entities: the Emmanuel Episcopal Church of Kempsville on June the 12th of 2012, April the 22nd of 2014, and October the 21st of 2014. Madison Landing LLC, also known as Oshel Rental Properties LLC, on April the 26th of 2011, and the 25th Street Associates LLC on March the 11th of 2014. Those are the allegations at this particular point in time. Special Agent Cully will be serving those summonses on Mayor Sessoms. Mayor Sessoms, we've made arrangements so that he will sign those summonses, which is basically his promise to appear. The case is tentatively set for trial on December the 7th in the Virginia Beach General District Court. Of course, that is very much subject to change because we did not consult with defense counsel as to their availability on that particular date. The only other thing I can add at this particular point in time, and I do ask you to be mindful of the fact that I really cannot comment on any of the facts that aren't alleged in the summons. The rules of professional conduct that judge my ability to practice law prohibit me from trying the case in front of the media. They require me to try the case in the courtroom. What I can tell you is that the Virginia Conflict of Interest Act does have some requirements of our public officials. It does require that they have a personal interest in a transaction, that they either abstain from that transaction or they make a number of public declarations. The allegations in this particular matter are that Mayor Sessoms failed to make the public declarations that were required by statute. And with that, I'll take any questions that you may have.
Mr. Doucette, all 3 of these dealt with something considered consent agenda items.
Correct.
Consent agenda items, no one was opposed to them, and they were recommended by staff. They were unanimous in their final votes. Does that matter in going to intent of what was in the heart of William Sessoms?
Well, as I understand consent agendas, is any one of those items can be removed, or in the alternative, one can abstain on a particular item in a consent agenda. The votes that I saw from Virginia Beach over the last 5 years under a number of different issues, maybe not in these particular 5, but I saw other members of council who had abstained on a particular item that was on the consent agenda. So the short answer is no, it does not. The Conflict of Interest Act does not differentiate between consent agendas and actual items that are voted on individually.
But does it go to intent also? Criminal intent or just sloppy?
Well, again, the Conflict of Interest Act, it's a very interesting act because it has a number of technical requirements on it. It basically says you shall do this. You shall make these declarations if you have a personal interest in this particular transaction. I can also say, as a public official subject to the Conflict of Interest Act, that I, as everybody else does, have to have biannual training on the Conflict of Interest Act. We go over it. We are required to know what is in it. The Conflict of Interest Act also has a provision in it that allows for any public official who has a question as to whether or not they might have a personal interest in a transaction to ask either the local government attorney or the Commonwealth's attorney for an advisory opinion as to whether or not they have such a conflict. The local government attorney's opinion is basically for good faith, that they had a good faith reliance if the person is ultimately charged with a violation. A Commonwealth attorney's opinion, on the other hand, is basically transactional immunity. If the Commonwealth attorney says you don't have a conflict, and it's ultimately later on determined that you did in fact have a conflict, that is basically an immunity in opinion. Let me take some other questions.
So you said that the mayor never declared, he never abstained from any of this. Could he have? I mean, could he have just
That's a question you'll have to ask him.
But that's something that it wouldn't have impacted any of the votes if he would have.
No. Again, the Conflict of Interest Act doesn't say it would have an impact on the votes. It says if you have a personal interest in the transaction, you shall make these declarations. Either abstain with a public declaration, or the other declaration you can say is, I have a personal interest in this transaction. However, it impacts 3 or more people, or I'm in a group or an association that is impacted by this particular vote. I promise I can be fair and impartial, and if you make those declarations, you can then vote on it.
So this could have been avoided if he would have just done that?
Those are the allegations that we are placing at this time, yes.
The mayor signed a document when he was first elected, kind of a blanket sheet saying that there will at times come votes before the council that he's not aware of with ties to his business with Town Bank. Does that sheet factor in at all to this at all?
No.
No. Why not?
Because, I mean, basically, I absolve myself of any responsibility, sign me. I mean, if that were the case, then any council member would do the same thing and say, I'm not responsible for what I do, and here's my declaration that says I'm not responsible. So, no, it does not have any bearing.
The fact that he had signed waivers or seek opinion from the city attorney before on other matters, he's done this maybe 11 or 12 times and has abstained from voting. Does that build your case that he knew the difference, he knew what the process was, and then failed to do it in these cases?
And again, I think we're now transcending that line into what goes on at trial. And again, I'm not going to try the case out here in the plaza.
And my last question in this round here is, if he is found guilty at the end of his appeals, which he certainly will, would the act call for him to resign?
There's no requirement that he either resign or be removed as a result of violating this particular code section for which he is charged. That would be ultimately up to the voters of Virginia Beach as to whether or not he stays in office.
But it could be only through some type of a plea agreement that he would say, okay, if you do this, then I'll resign. That's the only way he would be forced to resign. Is that true? Or
well, I'm going to repeat what I said. There's nothing in this statute that requires his removal or his resignation if, and I strongly emphasize the word if because he has the presumption of innocence at this point in time, if he is found guilty of one or more of these violations, there is no requirement in the statute that he either be removed or that he resign.
Well, what are the severities of charges then? I mean, because I heard it was very similar to having an open container in Virginia.
I think it's probably less. It's a maximum $500 fine for each of the violations.
So why are we here today then?
Because
if it's just an open container charge or less.
Well, I mean, are we going to treat the mayor any differently than we treat any other citizen? And my response is no. These are requirements. The Conflict of Interest Act is there for the transparency of government. And, you know, as far as the punishment is concerned, I don't decide what the punishment is. The General Assembly sets forth the range of punishment as far as these particular offenses. Some are Class 3, some are Class 1 misdemeanors. Class 1 misdemeanors are jailable. The General Assembly said these are Class 3 and they're not jailable. So that's not a question necessarily for me. That might be a question for any member of the General Assembly or the State Senate.
Mr. Doucette, can I just ask, can you talk about the role of John Holland, of the Virginian pilot, in revealing these issues?
The role of John Holland was he wrote the article on November the 8th of 2014. As a result of that, I believe that was why I was appointed as special prosecutor. That's the end of it.
There were other allegations in the pilot article that you said there wasn't enough evidence for. Can you go into that a little bit?
No.
Okay.
But there were statute of limitations had run out.
On some of them, yes. And basically there are 2 statute of limitations that apply in a conflict of interest violation. One is, and I'm going to talk as far as local government official is concerned because it's different for state officials. But one is if there's a 1-year statute of limitations from the day that the Commonwealth's attorney knew of the violation, or it's 5 years from the date of the transaction, whichever comes first. And so there were a number of the allegations in the pilot article that were more than 5 years old. We spent almost no time looking at those because it was going to be a exercise in futility. We just didn't need to do that because we weren't going to go anywhere. The statute of limitations had run. On the other ones, you know, we just basically came to the conclusion that there was insufficient evidence. I am required, as my duties as a prosecutor, is there has to be sufficient probable cause. And if I'm not satisfied that there's sufficient probable cause, I am required not to bring those charges. And I take that oath very seriously.
What went into this investigation? It was almost a year long, and you said that you guys had some hurdles to jump in the legal process and getting some financial documents from Town Bank.
Yeah, and again, I want to stress that it was not Town Bank's fault. I think I've said that several times. Town Bank was willing to cooperate, but Town Bank did want some legal process in case somebody came back later on and said, oh, you violated my personal privacy. And they're certainly entitled to that. We did present a number of subpoenas to a special judge who had been appointed to the case. The judge found that there was insufficient evidence to grant the subpoenas. Ultimately, we were able to get some search warrants. We tweaked our affidavit, and we were able to get some search warrants to get the information from Town Bank. But we, again, I want to stress that it was not that Town Bank failed to cooperate. They did, in fact, cooperate with this. They just wanted the legal process as their sort of legal protection.
Is that why it took so long?
Yes. I mean, again, we kept asking for, you know, the situation is I'm 4 hours away. The judge is about 3 hours from here. He's retired. I mean, he was on vacation a lot, yeah, it was just a very long, slow process. My communications with the judge were all by U.S. mail, no email. It was just a long process. This has just dragged it out, and so ultimately, obviously, the other statute of limitations beside the 5-year runs on Sunday, and so for the last several weeks, we've been very mindful that we had this statute of limitations that we had to comply with or else. So
I'm curious about when the judge was failing to give you the subpoenas that you requested. He said there's insufficient evidence. What was the feeling? What was the insufficient evidence? What was he asking you to get that you weren't able to provide?
And again, now you're crossing that line, and that's fine. That's your job to do, and my job to tell you I can't go there.
Aside from the state police, any other agencies involved with this investigation?
No, just the state police. Under Virginia, I suppose I ought to. Under Virginia law, in order for the state police to get involved in the investigation of any elected official, they have to have the permission of the Attorney General and of Virginia. And so I did contact the Attorney General of Virginia back in December and asked for their authorization to look into this matter. So that is the only involvement as far as the Attorney General's office is concerned. It's basically, for the most part, it's been me and Agent Culley. I mean, there have been other state police agents involved to a smaller degree, but it's basically been me and Agent Culley.
How much have you been able to contact or had contact with the mayor over the last year, and has he cooperated throughout the whole thing?
I have not had any contact with Mayor Sessoms. He's represented by counsel on this matter, and again, the rules of professional conduct prohibit me from going to him directly without going through his attorneys first. I have been in contact with his attorneys, and in fact, I was talking with them last night, making arrangements for the summons to be signed. But I have not had any contact with Mayor Sessoms.
On the 20.
Cooperative?
I'm sorry?
And they've been cooperative?
Well, in the sense that they just asked to be kept informed. They haven't been uncooperative. They're doing their job.
To get in the weeds a little bit on the 25th Street project, that dealt with a parking garage that council voted unanimously to go ahead and buy early, kind of changed what the deal was. The right vote for Town Bank to make more money was for them to vote no, we want the interest on the loans to continue on the parking garage. By voting to pay off the parking garage, they took away all that extra interest, maybe 8 months, from Town Bank. In that particular case, Sessoms voted yes, let's buy the parking garage, which cost his bank tens of thousands of dollars in interest. Does that weigh into his explaining why he made a yes vote to do what was in the best interest of the city, to get parking for the tourists coming up in the summer season?
It sounds like you and I want to switch places.
No.
No, I mean, you're doing all the testifying here, but again, I can't comment on that. I mean, you are asking me directly about what our evidence is, and again, I've said it over and over again. I cannot try it in this plaza. I have to try it in the courtroom.
So can the judge order him to step down? Is that a part of the act? I know it says the statute doesn't require it, but can the judge ask him to step down from office?
My understanding of Virginia law, I've been a prosecutor for 31 years, is that the judges have the authority that the General Assembly give them. And the General Assembly has not given judges the authority to remove someone from office for this particular violation. There are other statutes that are out there that are basically automatic. Any felony is automatic removal. Any sex offense is an automatic removal. This is not on that particular list. And so my understanding of Virginia law is that, no, a judge could not do that. I've had judges disagree with me. It's been a long, but I don't think, in my opinion, no, the judge could not do that.
I was just sent a quote, so I'm just going to read it. Apparently, this comes from the Conflict of Interest Act. Upon conviction thereof, the judge trying any the case, in addition to any other fine or penalty, may order the forfeiture or such office of employment. And
I'd forgotten about that, and I'd have to look at that again, because there are different provisions for different violations. Okay. And to tell you the truth, yeah, it is a complicated act, I'll grant you. When I get requests for advisory opinions, I mean, I go back and reread the whole thing from scratch, because you've got a definition of a personal transaction, and you got a definition of a personal transaction, a personal interest in a transaction, and it's sort of you're chasing your tail with the definitions. It is a complicated, and so to get back to some of the other questions that were raised before, well, does this mean it was an intentional violation? It doesn't require necessarily. Basically, we all know that the Conflict of Interest Act has these certain requirements. We are charged with knowing what's in that particular statute as public officials, and we have a duty to follow that.
So whether or not a judge can force them to step down is
I guess, I would have to look at that again. Okay. I've not gotten anywhere near that far as far as my investment.
In your opinion, do you believe that if he's found guilty of these charges, that he should step down?
Yeah, that is not up to me. I'm the Commonwealth attorney for the city of Lynchburg. That is up to the voters of Virginia Beach.
What other processes for removal of office are there? Is it just a recall, or there's no impeachment in Virginia?
We don't have a recall provision in Virginia. We do have a removal provision in Virginia. Under Virginia law, there is automatic removal for certain offenses, like felonies, like sex offenses. Otherwise, there is a provision, and I think it's entitled 24.2, but I can't remember for sure, but if 10% of the number of voters who voted in the last election for that office sign a petition seeking removal, it then goes to the circuit court for a rather expedited trial as to whether or not that person is removed. In my first 30 years of prosecuting, I'd never seen one. I've tried 2 of those in the last year. Both of those were well, one was the officer resigned mid-trial. The other one, they came back without a removal. Removals are very, very rare. I've not found a case citing a removal that was successful, that survived an appellate challenge.
You know, I spoke to Mayor Sessoms back in January, and he stood by the fact that he has done nothing wrong. Any comment on that?
And again, you have to go back to Mayor Sessoms and ask him.
What are your thoughts on him saying that he's done nothing wrong?
Again, that's up to him. I mean, he can say. I'm not here to get into a contest with Mayor Sessoms as to what he believes or doesn't believe. My job is to look at the law, look at what the facts are, and decide whether or not there's sufficient evidence to go forward to trial. Ultimately, the judge is going to be the one who makes that determination.
You mentioned that you were really cramped for time the last couple of weeks and months especially.
Yep.
If you had another 6 months, another month, another week, would the charges have been different?
No, I don't think so. I think it just expedited things. I mean, it basically things that maybe I would have spent more time with my wife over the last couple of weeks, just because we would have had more time. But, you know, when you come up against these crunches, and we do, I mean, again, I was telling some folks here, I've got a jury trial in Emporia tomorrow. I've got a jury trial in Lynchburg on Monday. I have a very busy week ahead of me, and this is just part of it.
So tell me about the process. Virginia State Police came and took out the summons, I would imagine. Correct. And then what happens now? Well,
at this point, we've made arrangements for Mayor Sessoms to sign the summons. That's basically his written promise to appear in court.
Okay. When is that going to happen?
When is the return date on that is December the 7th.
So it goes through the General District Court. It's not like a direct indictment to circuit court?
That's correct. I mean,
so the process is still as normal as if someone got arrested right here, right now?
Exactly right, yeah. And again, because it's a Class 3 misdemeanor, there's no arrest. It's you sign a promise to appear, and that's all there is.
What do you think of the severity of this, even though it is just a Class 3 misdemeanor?
Well, again, the General Assembly has made this call. It's not my call to make. You know, they said in these particular violations, when you don't make certain declarations, it's a Class 3 misdemeanor. you know, it's totally up to the General Assembly. If they want to change that, they can change it. If they want to say it's fine, they do nothing.
Do you think this is a bigger deal than just having an open container like, Jason brought up?
Oh, absolutely. Oh,
Why is that?
Because of the transparency aspect to it. I mean, the public has to have confidence in what its public officials are doing, and that they're doing it, without there being any private interests that are involved with the whole thing. So yes, I do take it very seriously.
Do you think that maybe the legislature should revisit the whole state conflict of interest?
I'm not even
kind of murky.
They had primarily since Governor McDonald's trial, they have gone over it and over it and over it and over it, and I have no doubt that in the upcoming session they'll go over it again. I mean, what was complicated before, I mean, we are reviewing almost monthly now to see what, I mean, there are new provisions that go into effect as of 1 January, that even before the session gets started. So yeah, I have no doubt that as the General Assembly reacts to Governor McDonald's trial, and perhaps that they may very well go back and look at the Conflict of Interest Act again.
Sir, is this the only investigation that involves the allegations against Mayor Sessoms that you're aware of?
Yes, in the sense that I am only appointed for Conflict of Interest Act violations. I am not Mayor Sessoms' personal prosecutor. And so I'm only authorized to look into conflict of interest violations. If anything else comes to light, they would, like anything else that would involve an occurrence in the city of Virginia Beach, it would go before Mr. Stolley as Commonwealth's attorney. He would have to decide whether or not, and again, I'm not saying there is, I'm just saying that would be the process, is that it would then go to Mr. Stolley. Mr. Stolley would decide whether he had a conflict and then ask for a special prosecutor at that point in time. But I'm only involved with the conflict of interest.
Are you aware of any other open investigations?
I am not aware of any other open investigations.
And, sir, you've kind of been asked this before, but can you just kind of talk a little bit about, I know that these are misdemeanor charges, but there is kind of in the work that the pilot did and the charges themselves. I mean, there's kind of a message to voters and citizens about the way public officials should do their thing. So, I mean, can you speak to that importance of why we're actually here after a year of prosecuting these 5 misdemeanors, even though they're just misdemeanors?
And again, I think you predicated it. Well, it's already been asked, and I've already answered it, but I'll answer it one more time. Is yes, I do think that there is that the General Assembly has recognized, and I certainly think it's an important recognition that there be transparency in the dealings of public officials. Now, having said that, there are certain things that obviously do need to be done. I mean, that's why we have executive sessions. There are certain things that in order to be done effectively, you don't have that transparency. And so the General Assembly, in crafting the Conflict of Interest Act, I think has tried to find that balance of transparency as a default, and then require that there be certain requirements to going into executive session and coming out of executive session. The same for me as a public official. There's certain things that I'm required to make transparent as far as the Freedom of Information Act. I know that everyone here, with the exception of me, feels that the FOIA laws don't go far enough as far as prosecutors are concerned, or law enforcement is concerned, because all criminal investigative files are exempt from FOIA. But there are some very good policy reasons for that. And again, why am I here today? I'm here because I think that there needs to be a balance between what the public should know as far as its government is concerned, and balancing that with Mayor Sessoms' right to a fair trial. And so that's why certain questions I can answer, certain questions I can't answer. You'll just have to come to court and hear what I have to say when we get to court.